The best solution is to leave your assets in a trust until the kids can get old enough to manage it properly. And when I say trust, a lot of people kind of think, oh, rich people, really expensive, really complicated. But you can create a fairly simple trust in your will that says, when I die, create a trust, which basically means a separate bank account. And I want Uncle Mike to be in charge of that account. Whoever the conservator was can continue to manage that money. And I want him to watch the circumstances and see how things develop with my kid and give them money as is appropriate. And then when they reach a certain age, or he determines that they're mature enough to handle it, he'll transfer either the money to the kid, or even better, control of the trust to the kid. And there's some really significant things that you can do with that scenario that help prevent problems with if that child is getting divorced or going through a bankruptcy, or has been in a car accident and the blood-sucking lawyers are coming looking for all his money and wanting to take it away. If we leave it in that trust, then it's protected from all those things, and it can't be taken in divorce, it can't be taken in the bankruptcies, it can't be taken in the car accident scenario. And you've now given them an extra gift that creates kind of a rainy day fund that they can use in a way that protects those assets, but still control it the way that you intend your kids to do. What we're doing here, though, is we're building in rules for when that happens, as in what age, and how that money is used. And if we write those restrictions into it, then legally it protects the money and it protects your kids, so that you're in a scenario where it can do all kinds of wonderful things that avoid this kind of problem. Because, I mean, they've already lost a parent, or maybe even both parents in some scenarios. The last thing we want to do is leave them with, you know, a boatload of money and no experience or understanding of how to use it. Okay. Next slide. Let's see, adult children. Go ahead and go to the next one. The problem here is we're talking about 18-year-olds having a hard time managing money, but if statistics hold, there's a lot of adult children that have a hard time handling money as well. If I get a family in that's talking, you know, they've got 4 kids, I can almost guarantee that one of those kids is going to be stellar with money. They're going to be an accountant or an MBA or somebody like that that's really good with it. They're going to have a kid that has absolutely no idea how to manage their life, money or otherwise, and they're just a mess. You may have somebody that's got a problem with drugs, and then you've almost always got one that is going to have a rocky marriage where you don't know if it's going to last, and they may or may not be losing 50% of their property to their spouse. And you're in a position where you're looking at trying to give them their inheritance in a way that it won't be wasted or taken away from them. And this is where we get back to that same scenario that we were just talking about with the younger kids, is that you can still leave this to the kids in trust. And you can do it in a way that the money's transferred safely. And again, this is no more complicated than a will, but it just, you've got to have the provisions in that will that create what's called a springing trust that springs out of the will once you pass away. If you don't have a will, everything, just like we were talking about with the 18-year-old scenario, everything transfers outright, free of trust, right into their pocket, which sounds great in theory, but if they're in the middle of a divorce, it's awful. They've just lost half of everything that you gave them. If they're in a bankruptcy, they may have just lost everything that you just gave them. If they're in a lawsuit where somebody's suing them for a car accident, again, they could lose all of it. If you transfer it in trust, then the way this works, and it's kind of fun, and it sounds sneaky, but it's totally above board, and it's been vetted by the courts, and everybody agrees that this is an appropriate way to do it. But what you do is you say, I'm leaving the money to a trust, like the Brian Carl Marshall Living Trust. And that money goes into trust, and we've appointed somebody to captain that trust who we call the trustee. And their job is to use that money, invest that money in a way that's going to benefit whoever I've named as the beneficiaries, which is going to be my kids, because I want them to get it eventually. And I'm going to say that money can only be used for their health, their education, or their maintenance. Maintenance is a pretty broad term that basically means keeping them in the lifestyle that they're accustomed to. And when that trustee goes to give money to the kids, he's got to fit it into one of those three categories. And these are categories that have been developed over hundreds of years of law practice. And what that puts us in is a scenario or a situation where if the kids get into trouble and they're going through a divorce or a bankruptcy or a lawsuit or whatever else can happen, is they'll come to the trustee and they'll say, hey, look, I've got these lawyers chasing me for a car accident. It was my fault. I owe them money, but I don't have anything. They're squeezing me. They want the money out of the trust. The trustee can then, very appropriately, look at the trust and say, does that fit into your health, your education, or your maintenance? Now, I don't think it does, so you go ahead and tell them to pound sand, and we're not going to give them anything. And then once that lawsuit is over, I can start looking at giving you money again. But for the time being, I'm going to clamp down as a trustee and say no, because it's not for your benefit. It's going to be wasted on somebody else, and I'm not going to give you anything. And that doesn't sound so bad, but here's what kind of catches people as not so intuitive is that, say at a certain age, I want my kids to be in control of that money. So I say, okay, Jacob, my oldest, when he reaches 25 years old, I want him to be the trustee of his own trust. I'm going to divide it into equal parts for my kids, but Jacob, I'm going to have Uncle Mike be your trustee until you're 25, but then he's out and you're in. You're the trustee now. And Jacob says, well, I ran over that lady with my car, and now she wants all this money. She's going to come to Jacob and say, hey, I know you've got that trust, and I want the money out of it to pay my medical bills or whatever else. And he can then go, wearing his hat as Jacob, and say to his hat as the trustee, hey, Jacob, I need money for this lawsuit. And he can say, well, let me look at the trust. Is that my health, education, or maintenance? No, it's not, so tell him, forget it. And then he can put on his hat as his individual self and go over there and say, hey, sorry, I talked to the trustee. The trustee said, no, I can't give you any of that money, and it's just too bad. Now, it sounds unfair, but the fact is it works, and the law has been established, and they've found that it is fair, that it is something that we want to encourage people to do. You can't set up a trust like that for yourself. I can't go and set up a trust for myself saying, I'm going to put all my money in there because I know I'm going to get sued, and I want to tell them no. But in this particular scenario where we were talking about passing money from a parent to a child, it is possible, and it's even encouraged, that you create a trust like that for your kids so that you can say, hey, look, this is not regular money that I'm giving you. This is a protected asset, and if you're smart, you'll leave it alone, you'll invest it as the trustee of that trust, you'll let it grow, and if anything ever goes wrong with your personal life and you lose everything that you have to whatever problem came up, you've got this to fall back on. And it will remain safe and separate and untouchable while you go through that bankruptcy, or while you go through that divorce, or while you go through that lawsuit. And then when you come out the other side and you're devastated financially and you don't have anything, you can turn to the trust. And it has the flexibility in those categories of maintaining your health, your education, your maintenance, that maintenance factor especially, to basically say, you can use the money to buy a house, you can use the money to buy groceries, or to maintain a gym membership, or to go back and get training, or a new college education, or whatever you want to do. And all of a sudden, they start thinking about mom and dad and this genius idea that they had to put their will together and blessing their name forever because they couldn't have done it for themselves. Okay? Now, you will have kids who say, thanks mom and dad, but this is just too complicated, I don't want to mess with it. If they want to draw the whole thing out of the trust, they have that flexibility. If you've appointed them to be their own trustee at a certain age, there's no restriction that says that they can't go in there and empty out the bank accounts and go and do whatever they want with it. Which is kind of what would have happened by default if you didn't have a will anyway. But what you're doing is you're giving them the option. You're saying, hey, you can do what you would have done regularly anyway, but what I've given you is this big gift on top of that that gives you the option at least of keeping this thing locked down and safe so that it can't be taken away from them. Okay. All right. Summary. We've got you're not dead at all but incapacitated. We've got your wills and trusts that protect your children, whether they're minors or adults, and appoint somebody to take care of your young children. And then we've got, I guess not listed there so much, but also your living will that kind of gets you in that not dead yet scenario where you can give instructions for how you'd like things to go.